Welcome to the 10th lecture of this lecture series on international arbitration practice. We have been discussing about drafting arbitration agreements in the first chapter of this lecture series. In the last two lectures, we dealt in detail with the main components of an arbitration clause using the WWHW acronym. That is, what, who, how, and where. These components constitute the fundamental aspects of any arbitration clause. So, one would not be in fault in focusing on learning these aspects. If you recollect, we had discussed in lecture 7 that having a checklist is one of the crucial strategies to avoid pathological arbitration clauses. In this lecture, we will create such a checklist, but we will do it for these important components of arbitration clause that we have been discussing. So let us start with building such a checklist step by step. There are various checklists available in the public domain for many jurisdictions. Note that these checklists, especially those that claim to be comprehensive, cannot be general checklists. Rather, they will be rooted on some jurisdiction or the other. You could have a look at any of them. You may ask how to use such a checklist. Say, in case you're vetting an arbitration clause, use the checklist to see if the arbitration clause in question covers those items listed in the checklist. If you want to draft the arbitration clause from scratch, this checklist will be useful to see if all the portions are covered comprehensively. We will develop this checklist as and when we cover various topics under the chapter arbitration agreement. For the purposes of this lecture, we will be covering only that portion of the checklist which deals with the WWHW questions. The what question, you may recollect, deals with what disputes are to be referred to arbitration. If the intent is to submit all disputes arising out of or in connection with the agreement for arbitration, then the checklist would say so. But if there is an intent to accept or exclude certain matters, the checklist will note accordingly. These points are captured in serial numbers 1 and 2 of the checklist. Serial number 1 says whether all disputes arising out of or in relation to the agreement is sought to be referred to arbitration. The second serial number talks about clauses or matters that would be excluded from the scope of arbitration clause. It reads whether certain matters would be excluded from the scope of the arbitration clause. These are popularly known, especially in India, as accepted matters. We will discuss this topic of accepted matters in greater detail later. But for now, just know that parties could also agree to exclude certain matters from the scope of the arbitration clause. There is also another dimension to this. Parties may agree to exclude certain topics or certain disputes from the scope of the arbitration clause for the time being. To give an example, parties may agree that accounting related issues in an agreement or even say technical matters and disputes arising thereof would be referred to an expert rather than an arbitrator. So this is also possible, but we will discuss all these things in greater detail later. For the moment, we focus on the WWHW questions. Next, we deal with the who question. The who question asks who would be the arbitrator, who would be the arbitral institution, or who would be the appointing authority. So the checklist would first state whether the intent is to provide for ad hoc or institutional arbitration. For those who are not familiar with the terms ad hoc and institutional arbitrations, institutional arbitration is used in contradistinction to ad hoc arbitrations. In institutional arbitration, the arbitration is managed by an arbitral institution, usually chosen by the parties. This management includes services relating to hosting the arbitration, constitution of the arbitral tribunal, providing a secretary to manage the affairs of the arbitral tribunal, providing venue or conference rooms for hearings, web platforms for hearings, etc. Examples of prominent arbitral institutions include the International Chamber of Commerce's International Court of Arbitration, London Court of International Arbitration, Singapore International Arbitration Center, etc. Some of the prominent Indian arbitral institutions include the Mumbai Center of International Arbitration, Indian Council of Arbitration, etc. The Latin term ad hoc means for that purpose. When an arbitral tribunal is appointed specifically for resolving a particular dispute, such a tribunal is known as an ad hoc tribunal. Here, the tribunal, with the help of the parties, of course, manages the arbitration. Institutional and ad hoc arbitrations have their inherent advantages and disadvantages. Primarily, an arbitral institution may have control over managing the arbitral proceedings efficiently. As such, they may be suitable for arbitrations that are of high stakes. But considering their costs, institutional arbitration may not be suitable in disputes of smaller stakes. However, world over, there is a preference for institutional arbitration. But India is an exception where it appears that the number of ad hoc arbitrations seem to be more. Now, coming back to constructing the checklist, the serial numbers in the checklist would provide for these aspects that are provided in bold from serial numbers 3 to 5. These read whether the arbitration clause should provide for institutional arbitration or ad hoc arbitration. So, when you draft or vet an agreement, this choice needs to be made. 4. Whether there should be a process for appointing the arbitral tribunal. So, whether the agreement itself should provide for a process. And 5. Whether there should be an appointing authority in case the appointment process agreed upon by the parties fail, or where the arbitration is an ad hoc arbitration. Generally, for institutional arbitration, the institution itself takes care of the role of appointment of arbitral tribunal. Therefore, you need not worry there. Next, we deal with the how question. That is the procedural aspect of the arbitration, such as the applicable rules or the statute for conducting the arbitration. The arbitration clause should provide that the arbitration would be conducted in accordance with, say, the unsettled arbitration rules or the procedural aspects of the law of the seat of arbitration, or if there is a choice of arbitral institution, as per the rules of that arbitral institution. Here, you must note that certain institutions like the London Court of International Arbitration, Singapore International Arbitration Center, etc., provide administrative support to ad hoc arbitrations. In those cases, two kinds of services are broadly provided. One, these institutions act as appointing authorities, and two, they help the arbitral tribunal in administering the arbitrations. So, even if the parties agree for conducting the arbitration as per ad hoc arbitration rules, such as the unsettled arbitration rules, they could subsequently let an arbitral institution provide administrative support to the arbitral proceedings. Accordingly, serial number 6 is updated in the checklist and it reads whether the procedure of arbitration would be governed by specific rules, institutional or ad hoc, or the procedural rules contained in the arbitration law of a particular jurisdiction. It is very common for parties to agree that the procedure of the arbitration would be as per, say, the Arbitration and Conciliation of 1996 of India or the Arbitration Act 1996 of UK, etc. And lastly, the where question. This is important and we will explain why in a subsequent lecture. For now, sheet will occupy the 7th row of the checklist and it will state where will be the seat or place of arbitration. Note that the term seat or place are synonymous. A closely related question is whether the tribunal can conduct the proceedings in a place other than the seat of arbitration. A detailed checklist would have a provision for this as well. So we add another row to the checklist which will state whether the tribunal could conduct proceedings in a venue other than the seat of arbitration. Thus, the checklist would read 8. Whether the proceedings could be heard in a venue other than the seat of arbitration. Note that the terms seat, place, and venue connote different things, especially seat and venue. These are totally different in international arbitration parlance. Therefore, you must not confuse yourself. Venue generally refers to a place where the arbitral proceedings are actually conducted. They may not be the place or the seat of arbitration to which the arbitration is linked from a legal perspective. Both these things are different, and we will deal with this in greater detail later. So that's all in this lecture. For those who are wondering, we have a lot more to cover under the topic of arbitration agreements. We will do that in the next few lectures. Till then, bye bye and stay safe.